All right, good morning, everyone. I'm Judge Corey Amanda Cawthon. We're here for first appearance court this morning. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak with your attorneys before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that these attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following this morning's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we're getting started this morning, we do have a large docket. I'm going to address a few cases that have been requested to be called out of turn. I'll start with our two cases from Maine. I'll do the cases that are called out of turn, then I'm going to go to the Spanish interpreter cases, and we'll go to the sign-ins after that. First up on page 9 is Timothy Agner.
Please approaching, Judge.
Thank you. Good morning, Mr. Agner.
Good morning.
Mr. Agner, you're before the court this morning on 3 traffic capiases. These are related to charges for operating with a suspended driver's license, first offense, operating with a suspended driver's license, second offense, and there's another driving with a suspended driver's license. I find probable cause. I do see that Mr. Agner has a status hearing with his division judge tomorrow morning. In light of that, do the parties wish to be heard?
No. Judge, I did advise Mr. Agner as far as court date tomorrow, but he wants to first see if the state has a plea out form today on these offenses.
No, Your Honor, I'm not inclined to resolve 3 DWSs at one time at first appearance.
In that case, Judge, I did advise Mr. Agner he'll be seeing his division judge tomorrow morning, so
All
nothing
right.
to add.
Thank you. Good luck, Mr. Agner. Next, on page 13, Daniel Adams.
Check him out.
He's approaching, Judge, here. Maine?
Thank you.
Judge, at this time, I would invoke Mr. Adams' right to remain silent and strongly urge Mr. Adams to remain silent.
All right. Mr. Adams, you're before the court this morning on 1 charge of first-degree premeditated murder. I find probable cause, and I will hear from the parties at this time.
State would be seeking a finding of proof evident or presumption great for first appearance purposes. Request that Mr. Adams be held no bond. This is based on the affidavit, which includes but is not limited to Mr. Adams' alleged confession.
It's Gomez, Spanish.
All right, Mr. Miller, defense's response.
Yes,
That's your only one.
on page 22.
Yeah.
One moment, Judge.
All right, pulled it, right?
Yes. Your Honor, I would just object to the court finding proof evident, presumption great, based solely on a hearsay affidavit, and would reserve any further argument for another day.
All right. I have reviewed the probable cause affidavit in this case based on the allegations, including the statements that Mr. Adams made to law enforcement that are outlined within the probable cause affidavit. At this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Adams be held no bond on this charge. that is without prejudice for him to have the appropriate Arthur hearing before his division judge to further address this matter. Thank you.
Just letting you know. No, I'm just letting you know you don't have to wait for the second.
Thank you. All right, I have two cases that North Broward is requested to be called out of turn. On page 7, Pablo Alejandro Gomez.
Which we have an argument as to probable cause.
All right.
Mr. Gomez, I'm going to advise you to remain silent at this point and let me do the talking. Yes?
All right.
Sure, yes.
Mr. Gomez, you're before the court this morning on one charge of making a false report concerning the use of a bomb, explosive, or weapon of mass destruction. Mr. Miller, I'll hear your argument.
Judge, he's charged under section 790.163 of the Florida statutes. And I did a little case law research this morning, and I would argue that there is no probable cause to continue to hold Mr. Gomez. He is alleged to have stated, and I'm quoting from the arrest affidavit, I'm going to shoot the cops in their head. I hate the cops more than anything else. This amounts to, if it's true, amounts to a statement of future plans and not a report of a false report. And I'm going to refer the court to a couple of cases that I found on this issue. DB v. State, 825 Southern 2nd, 1042. A threat to take action in the future could not be characterized as a false report. And in that case, a juvenile threatened to burn down the school. Notably, the appellate court said statute prohibiting one from making a false report with the intent to deceive, mislead, or otherwise misinform any person concerning the placing or planning of any bomb, dynamite, or other deadly weapon or weapon of mass destruction is violated when a person knowingly makes a false report that a bomb or other deadly explosive has been placed or planted, not from threats to take some action in the future. In the case LCV States, 283 Southern 3rd, 442 out of the 2nd District, the court there found the juvenile expression of his desire to shoot people at his school did not violate false reporting prohibition in juvenile delinquency proceeding for making false report concerning use of a firearm in a violent manner, where juvenile statements, even if understood to communicate design as well as desire to shoot students and teacher, merely communicated a plan to inflict future harm. And finally, Judge, in JAW v. State, 283 Southern 3rd, 896, a firearms-related prohibition in a bomb scare hoax statute prohibits knowingly making false and misleading reports about active shooting type situations. None of this applies to Mr. Gomez situation. He was arrested under this statute. He's being held with a $100,000 bond. He's been in custody since the 18th of February. And Judge, I would ask the court to find that there is no probable cause to hold him under this or any other statute and to release him on his own recognizance immediately.
Mr. Linder, the state's response.
Well, first of all, Your Honor, under Rule 3. Under Rule 3.133A1, Mr. Miller's not in a position to make a probable cause objection since there is a valid arrest warrant signed by Judge Garcia Wood. Secondly, Your Honor, at a minimum, to say he's not violated any law is an invalid argument, since at a minimum, he's made threats to specified individuals. And lastly, Mr. Miller arguing how long the defendant's been in custody, he's been in medical reset. Not once has the defense objected and say that the court should set a bond and hear argument. So I don't understand why he's arguing that that should be a mitigating factor when no public defender has had an objection since the 19th.
Given the fact that Judge Garcia Wood made her finding when she signed the warrant to arrest Mr. Gomez in this case, at this time, I'm going to uphold her finding of probable cause. I'll hear the parties' recommendations as to bond and release conditions at this time.
Judge, I think I've demonstrated that Mr. Gomez did not violate the statute for which he is being held. Whether there is another statute, that's something that the state attorney is going to have to determine, but this statute does not apply to these facts. And so I'd ask the court to release him on his own recognizance.
Okay. Mr.
Your
Miller?
Honor, I'm going to be asking that the court keep the bond in place, that if Mr. Gomez posts his bond, that he be supervised by pretrial release services level 1 GPS monitor, that he be ordered not to possess any firearms, weapons, or ammunition.
I never have, and I never
Mr.
will.
Gomez, I've asked you to please refrain from talking. Let me do the talking for you. That's my job.
Your Honor, I can advise the court for bond purposes. I've spoken with Detective Versteeg, who is with BSO's Threat Management Division. He authored the arrest warrant. There is great concern with respect to Mr. Gomez's mental health. His actions give concern about a lack of predictability and that lack of stability. Your Honor, law enforcement, particularly Detective Versteeg, have had contact with Mr. Gomez's mother, who he resides with, who has also shared concerns about his mental health. I think the court should also be aware where Mr. Gomez resides with his mother is practically across the street from this particular police district office. So there is an additional concern for the safety of not only any law enforcement officers that work in that district office, but any other employees or any members of the public that may have business at that district office.
Does Mr. Gomez have any priors?
He does not, Your Honor.
Judge, he's an 18-year resident in South Florida. He's been living with his mother for the past 13 years. He does have a condo. He's reporting that he has a condo that he can live at. I believe, Mr. Gomez, you can answer this question. That condo is at a different place from where your mother lives. Is that correct?
What do you want me to answer?
Okay, you mentioned earlier when I spoke to you on the phone that you had a condo that you
I'm
could
mixed
live at?
bipolar with severe psychotic
Okay.
episodes. I just turned 38, and I live with my mom.
Okay.
Does that not show that I've been hospitalized for hundreds of days in hospitals?
Thank you, Mr.
Over
Gomez.
13 different hospitals.
All right, thank you, Mr.
I don't know
Gomez.
where these cops
Okay,
come up with these
I've heard
words,
what I need to
but
hear.
they're not true.
Mr. Gomez, thank you. All right, at this time, I'm going to leave the bond in place as it is. If the monetary bond is posted, Mr. Gomez will be placed on pretrial supervision with a level 1 GPS monitor. There will also be an order that he possess no weapons, firearms, or ammunition until further order of the court. If there are underlying mental health issues going on with Mr. Gomez, then I believe it would be in his best interest to have his attorney bring that issue up with his division judge so that that matter can be addressed and he can get whatever assistance is needed to help the situation. All right, good luck, Mr. Gomez.
Judge, I would just renew my objection to him being held on these charges.
That's fine, thank you. I'm sorry, the weapons, yes, yes. All right, the next case, I have 2 more cases that have been requested to be called out of turn. Next is Jabbar Tolbert on page 7. All right, good morning, Mr. Tolbert.
Mr. Tolbert would like to resolve this case if the state has an offer for him. Mr. Tolbert, please don't talk.
All right, Mr. Tolbert, you're before the court this morning on 1 charge for trespassing on property, not a structure or conveyance. I find probable cause. Is there an offer from the state in this case?
No, Your Honor, I'm showing that he just had two cases dismissed on January 27th of this year on competency grounds. I'd be requesting that this matter be transferred to Judge Lerner Wren.
All right, that's fine. I'm going to leave the standard bond in place and sign an order transferring the case to Judge Lerner Wren so that she can get Mr. Tolbert in front of her within the next couple of days. Thank you. Good luck, Mr. Tolbert.
Mr. Tolbert, the case is unable to resolve. Your case is going to be transferred to Judge Lerner Wren. You can discuss resolving the case with her.
Well, I called, the public defender, they said it was resolved already.
Ren, I spoke to you
They said I
on
gotta
the
send
phone,
it away.
Mr. Tolbert, where I explained to you we might not be able to resolve your case, and that's what happened. We're not able to resolve your case, so you're gonna have to take it up with your division judge. Okay? Good luck, sir.
Good luck, Mr. Tolbert. Next is Mitchell Arnold on page 11. Is he at North Broward?
That's right, Anna.
Okay, thank you. All right. Good morning, Mr. Arnold.
Good morning.
Mr. Arnold, you're before the court this morning on one charge of trespassing on property, not a structure or conveyance. I find probable cause. I'll hear from the parties. Does Mr. Arnold wish to resolve this case if there is an offer? All right, Mr. Linder, is there an offer from the state for Mr. Arnold?
Judge, Mr. Arnold will resolve the case if the court is so inclined.
All right.
The offer, Your Honor, would be adjudication time served, no return.
Mr. Arnold, if you would like to resolve the case today, the state's offer to you would be an adjudication of guilt with time served, and there would be a no return order to the Dollar Tree that's at issue in this case. Do you understand that, sir?
Yes, ma'am.
Do you wish to accept that offer today?
Yes, ma'am.
All right, I'm going to ask you a few questions before we conclude. To begin, will you please raise your right hand?
I'm in handcuffs.
Do your best. Perfect. Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can go ahead and put your hand down. And Mr. Arnold, do you understand everything we've discussed so far this morning?
Mm-hmm.
Is anyone
Yes, ma'am.
forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand?
Yes, I have.
Okay, that's all right. Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
Okay. And Mr. Arnold, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Once again, your sentence will be an adjudication, time served, and remember that there will be a no return order to the Dollar Tree that we discussed, and you understand that?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome. All right, what cases need the Spanish interpreter? I'm sorry? Okay.
Judge, there's three gentlemen that require Spanish interpreter. The first one is on page 5, and that gentleman is Mr. Lopez Roldan. He has private counsel, Mr. Philip Paramilla.
Okay, and give me the
The
other two.
second is on page 7 of the court's docket. His name is Mr. Rafael Domingos Chacon, page 7. And on page 12, the last individual at Maine is Mr. Jose Romero. Señor López Roldán, ven. Ahí está su abogado privado, el señor Jaramillo.
All right, we'll start with Mr. Lope for my interpreter. Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
Your Honor, for the record, Igor Feliciani, good morning, Your Honor.
Thank you.
Judge, for the record, Felipe Jaramillo on his behalf.
Thank you, Mr. Jaramillo. Good morning, Mr. Lope.
Buenos días, señor López.
You're before the court this morning on 2 charges.
Usted se encuentra frente a la corte a la mañana del día de hoy por 2 cargos.
Count 1, battery, causing bodily harm, domestic violence.
El cargo número 1 es agresión física con daños físicos en un marco de violencia doméstica.
Count 2 is an immigration hold, which has a no bond hold.
El cargo número 2 es una retención por concepto de migración que no conlleva una fianza.
I find probable cause.
Hallo que hay causa probable para ambos.
To begin, before I hear from the parties,
Para comenzar, antes de escuchar de las partes,
Mr. Lope, so that you understand with regard to the immigration hold,
para que usted entienda, señor López, algo con respecto a la retención de inmigración,
since that has a no bond hold, it
Listo que
means, that's okay. Since it has a no bond hold, it means that you'll go before an immigration judge in order to address that matter.
visto que esto es una retención sin fianza, ello implica que usted deberá presentar frente a un juez de inmigración para resolver ese asunto.
I will hear from the parties on count 1.
Sobre el cargo número 1, ahora escucharé a las partes.
Your Honor, Mr. Jaramillo and myself have agreed to a $2,000 bond and no victim contact, if that is acceptable to the court.
Um,
I'm sorry.
Judge, we did agree to the $2,000 bond, but as far
Oh.
as no victim contact, his wife is here. She's the victim in the case. She hired me to represent Mr. Lope. He's been married to her for 3 years. She wants to ask the court to delete that no contact order.
Slow down, so that our
sorry.
interpreter.
My apologies, I misunderstood.
That's all right. Let me let him interpret first.
La Fiscalía, su señoría, ha llegado a un acuerdo con el señor Jaramillo para fijar una fianza de $2,000 y una orden de no contacto con la víctima, lo cual consideramos aceptable. La defensa quisiera ser escuchada a su señoría con respecto a la orden de no tener contacto con la víctima. La esposa del señor se encuentra acá, ellos han estado casados por un periodo de 3 años y en este momento quisiéramos solicitarle a la Corte que eliminara esa orden de no tener contacto.
Sorry. Judge, she's here if you want to take testimony from her. I know she told me to try to ask the police not to take him into custody, but of course it wasn't up to her, it was up to the law enforcement officer.
Su señoría, la esposa del señor se encuentra acá en este momento. Quisiera saber si ella puede comunicarse con usted, su señoría. Esto que ella trató de hablar con los policías y para pedirles que no se llevaran al señor, más esa no era la decisión de ella, obviamente.
Can we turn the speaker off at Main? It's a little bit loud.
Apriete el botón. Apaga el micrófono, por favor.
Yeah, thank you. Okay. All right. I understand everything that you've told me, Mr. Jaramillo. I don't need to hear from the wife. I will take your testimony as an officer of the court. I'm going slowly since we have the interpreter. You want me to keep going? In situations like these, I can tell you that with very few exceptions, I usually impose the no contact order for the safety of both parties. If nothing else, it serves as a cooling off period for them.
Entiendo todo lo que me está diciendo, señor Jaramillo. No hace falta que escuchemos a la esposa. Tomaré su testimonio como fidedigno, visto que usted es un oficial de la Corte. En situaciones como esta, con muy pocas excepciones, yo suelo emitir una orden de no contacto, de que no haya contacto, en la vista de salvaguardar la seguridad de las partes y a la luz de lo que es considerado el periodo de enfriamiento de las partes.
Judge, may I say something? They do have a 3-year-old child. May they at least have limited contact via phone for purposes of parenting the child?
Su señoría, en este momento solicitando que ellos tienen un hijo, una
niña.
hija de 3 años, pediría que hubiera un contacto limitado para los efectos de todo lo que tenga que ver con ejercer la patria potestad sobre esa niña.
Since they have you as counsel, I would be fine with you acting as a third-party intermediary. If it needs to be modified, it can be handled with the division judge later
Sounds good,
on.
Judge. I understood.
La Corte, considerando que el señor es el abogado de las partes, no tiene problema si el abogado actuará como un intermediario y si quiere modificar esos términos, lo pueden hacer frente al juez de división.
Mr. Lopez, so that you understand my no contact order,
Señor López, para que usted entienda finalmente los contactos de la orden de no contacto.
until further order of the court,
Hasta tanto haya una nueva orden de la Corte,
That means you are not to be in the same place at the same time as the alleged victim.
Usted no podrá estar en el mismo lugar y al mismo tiempo que la supuesta víctima.
That no contact order also includes no phone calls or text messages.
La orden de no tener contacto incluye no hacer llamadas telefónicas entre ustedes ni enviarse mensajes de texto.
No third-party contact or social media contact,
No pueden tener contacto a través de terceros ni contacto vía redes sociales.
with the exception that if some sort of coordination needs to happen, you may do so through your attorney, Mr. Jaramillo.
La excepción de que necesiten hacer alguna coordinación con respecto a cualquier tema, que lo haga a través de su abogado, el señor Jaramillo.
Do you understand that, sir?
¿Entiende esto, señor?
Yes.
Okay, thank you.
Mr. Golden, I see you this afternoon, sir.
All right,
Thank you, Judge.
thank
What do
you.
you say?
He'll see you this afternoon.
Okay.
Okay, thank you, Mr. Lopez. Good luck. All right. Our next case for the interpreter on page 7, Rafael Dominguez Chacon.
He's approaching, Judge.
Thank you.
No, I mean, when you get there, page 7.
Just give me one moment. My system is doing something weird. I want to make sure it's working properly.
Señor Domínguez, deme un momento. El sistema no está trabajando bien. Quiero asegurarme que esté trabajando bien.
Me at Maine.
I am, Judge.
Okay. All right. Mr. Dominguez, you're before the court this morning on 3 charges.
Señor Domínguez, usted está frente a la corte el día de hoy por 3 cargos.
Count 1, DUI, alcohol or drugs, first offense.
El cargo número 1 es una primera ofensa de manejar bajo los efectos de alcohol o droga.
Count 2, DUI with damage to property or person of another.
El cargo número 2 es manejar bajo los efectos, causando daños a la propiedad o persona de un tercero.
Count 3, DUI with blood alcohol level greater than 0.15.
Y el cargo número 3 es manejar bajo los efectos con un nivel de alcohol en la sangre mayor a 0.15.
I find probable cause for these charges,
Hallo que hay causa probable para estos cargos
and I will hear from the parties at this time.
y en este momento escucharé a las partes al respecto.
We're just going to be requesting a phone order, Judge.
Su señoría, en este momento solamente solicitaríamos acceso a su teléfono.
Anything further from the state?
¿La fiscalía tiene algo más que decir? No.
All right. I'll sign the phone order and leave the standard bonds in place.
Ok, la fianza queda estándar y en breve firmaré la orden de acceso al teléfono.
Good luck to you, sir.
Buena suerte a usted, señor.
Next will be on page 12, Jose Romero.
Señor Romero, ven. What's that? He's approaching, Judge.
Thank you. Good morning, Mr. Romero.
Buenos días, señor Romero.
You're before the court this morning on an ad charge.
Usted se encuentra frente a la corte esta mañana en un cargo agregado.
This is for an immigration hold.
Esto es por una retención de inmigración.
I find probable cause.
Hallo que hay causa probable.
And Mr. Romero, since this has a no bond hold, that means you will go before an immigration judge in order to address this matter.
Y señor Romero, visto que esto es una retención de inmigración, la misma no tiene fianza y ello implica que usted deberá presentarse frente a un juez de inmigración para resolver este asunto.
Good luck to you, sir.
Buena suerte a usted, señor.
Is there anyone else at Maine that requires a Spanish interpreter?
¿Alguien más necesita intérprete español en la cárcel principal?
Not here at Maine, Judge.
All right. Is there anyone at any of the other facilities that needs a Spanish interpreter?
Not for copy, ma'am.
All right. Thank you. Thank you very much.
Could I ask a favor real quick?
Yep.
Could you sign this form for me, sir? Write below your name now.
You got it.
Thank you so much.
Thank you, as always. You too. All right. We're going to our sign-ins now. First up, I believe private counsel is present on Brandon Butler. He's on page 20. Is he at the jail already?
Judge, right now the deputy's hurt, they're going to get him.
Okay, all right. Just let me know when he's ready and I'll come back to him.
Yes, Judge.
All right, then if he is present on page 23, Antonio Telfair, he was reset from yesterday.
Is he the guy that you told me that was in regular court? Judge, Mr. Telfair on page 23, I've been advised he's in regular court.
I assume that's for the VOP.
Room 5750.
I specifically had him reset to this morning because the state wanted to present some further evidence. I assume that's why Detective Benson is here. Mr. Linder, how
Have
do
the
you?
jail communicate with whatever the deputies, whatever courtroom he is, to have him brought back when he's done with his VOP hearing?
Yeah, okay. Mr. Romero, are you able to request that the deputies at the jail have him brought here to first appearances this morning when he's done with his VOP? Because we have a lengthy docket, so I'm sure we'll still be here by the time he's done. But I need him brought here as soon as he's finished with whatever hearing he's in right now.
They heard you, Judge, and they're going to try.
Perfect.
They're gonna do it.
Thank you so much. I appreciate that. All
Honor?
right, yes.
May we approach?
Yep, come on up. We'll go sidebar for just a moment. On the Telfair case, I've just been advised that the detective is able to be here for this afternoon. So you can let the deputies know I'm going to have him set on the afternoon docket. That way they don't need to rush and everybody will be fine with their schedules here, okay?
No problem. I think he heard you, so now he's getting off the phone.
Thank you. I appreciate it as always. All right, will you
problem.
hold that for me for a second? Thank you. Okay. All right, I have family present on Jamalise Shaw, who is on page 13.
Come on up.
Is there
Mr.
someone
President,
here on
Judge
Mr. Shaw's case? Okay, ma'am, are you just here to observe? Okay, that's fine. All right, good morning, Mr. Shaw. Mr. Shaw, you're before the court this morning on 2 charges. Count 1, resisting an officer, obstructing without violence. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause. Mr. Shaw, I do see you're going to have a hearing with your division judge tomorrow morning to address the VOP. So in light of that, do the parties wish to be heard on count 1?
No, Judge.
Okay, all right, thank you very much. All right, so ma'am, just so you know, he's gonna have a hearing tomorrow morning with his division judge, 9 o'clock. Not in this courtroom, it's with whoever his division judge is on the other case, okay? Thank you. All right, while we're waiting on Mr. Butler's case, is Mr. Shate here? There he is. Let me go to our municipal ordinance cases. All right, on page 1, Tamara Powers.
No problem.
Thank you.
Judge?
Okay. All right, thank you.
She's a medical research, Your Honor.
Thank you, Deputy. All right, on page 8, Patrick Michael Conche.
Mr. Conche, come on up, please. Yes. He's approaching, Judge.
Thank you. Good morning, Mr. Conche.
Hello, ma'am, how are you?
I am well. Mr. Concha, you're before the court this morning on 5 misdemeanor capiases. 1 through 4 are municipal ordinance violations. Those all relate to, let's see, 2 of them are for lodging. 1 is open container. 1 is for trespassing. And count 5 is a misdemeanor for trespassing. I find probable cause, and I'll hear from the parties at this time.
Judge, in reference to count 5, the state offense, Mr. Conche advised me he wishes to resolve these matters today.
Judge, after the 4 municipal cases, the city of Hollywood is not giving him an offer this morning. They prefer to go to the division.
Okay.
As far as the state charge, the documented offers withhold court costs, no return to 2001 Johnson Street in Hollywood.
All right,
Let me advise him, Judge.
go ahead.
Case today.
Judge, Mr. Conche wishes to accept the state's offer on count 5.
All right, Mr. Conche, you understand that you'll still have the 4 municipal ordinance cases that'll have to be addressed, right?
Yeah, and I'll get another court date for them?
Yes, you will. Okay,
All right, thank you, ma'am. I'll resolve them then.
okay, all right, so
On
Mr.
those 4, though, you're still going to be held in custody. I just want to let you
Yeah.
know that.
They're still gonna hold me in custody?
Yes,
That's what
Mr.
they're telling
Conche, you have outstanding capiases on those 4 cases, so if you want to resolve the 1 state case today, that's fine with me, that's your decision, but understand there's still 4 other cases that you'll have to go before your division judge on.
I'm massively confused here. These are just beer tickets and
I
Open
understand,
container
Mr.
tickets.
Conche, but if you don't go to your court dates, then warrants get issued, and then the police officers come and pick you up. All right, I tell you what, since he's got the 4 municipal ordinance cases that he's going to have to remain in custody on anyway, I think it may be in his best interest to address all of them at the same time, so that way he understands what's going on and is fully apprised of everything that's happening. All right, so I'm gonna leave everything as it is, and he'll probably be seeing his division judge within the week, I would assume, okay? All right, good luck, Mr. Conche. All right. Next on page 9 is Stefan Brown.
Eric, that's what he uses. Main jail.
He's approaching, Judge.
Thank you. Good morning, Mr. Brown.
Judge, they have offered a time-served matter, time-served offer for Mr. Brown.
All right, Mr. Brown, you're before the court this morning on 2 misdemeanor capiases. These are both trespassing charges. One is a municipal ordinance violation, the other is a regular state case. Okay, you said it's adjudication time served on the MO?
Correct.
All right, and Mr. Linder, is there an offer on the state case?
Your Honor, frankly, the documented offer from the site ASA involves probation. I would make Mr. Brown an offer of adjudication in 3 days. He has a significant history
3 days?
in county jail.
Let me talk to Mr. Brown, Judge.
Go ahead.
Judge, he wishes to accept the state's offer.
All right, so Mr. Brown, just to be clear on both of these, on count 1, which is the municipal ordinance trespass case, the offer's an adjudication, time served. Count 2, which is the state trespass case, it will be an adjudication with 3 days in the county jail. There will also be no return orders with regard to the locations of both of these alleged trespasses. Do you understand that, Mr. Brown?
Yes, ma'am.
Okay, and you wish to accept those 2 offers today?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Mr. Brown, do you understand everything we've discussed here this morning?
Yes.
Is anyone forcing you to resolve these cases?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorneys?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, Mr. Brown? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. As we discussed on count 1, your sentence will be an adjudication, time served. On count 2, your sentence will be an adjudication, 3 days in the county jail. You'll have credit for any time served. And as we discussed, there will be the no return orders. And you understand those orders?
Yes, ma'am.
All right, good luck to you, Mr. Brown. Next will be Thomas Gleason on page 9.
Mr. Gleason, come on up, please. There's Mr. Shake, your turn.
Good morning, Mr. Gleason.
Good morning.
Mr. Gleason, you're before the court this morning on a misdemeanor capias. This is related to a municipal ordinance violation for soliciting or panhandling. I find probable cause. Your attorney, Mr. Shea, is with me in the courtroom. And Mr. Shea, what are we doing in Mr. Gleason's case?
It'd be a time served offer, Judge.
All right, Mr. Gleason, if you want to resolve this case today, the city's offer is an adjudication, time served. Do you understand that?
I do, ma'am.
And do you wish to accept that offer today?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And Mr. Gleason, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
I understand.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Gleason, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you, sir.
Thank you, ma'am.
You're welcome. Next will be Earl Mitchell on page 9.
Mr. Mitchell. Mitchell, come on up, sir. Yeah. Go up and see the judge right there, and there's your private attorney. Mr. Shake, your turn.
Who?
Good morning, Mr. Mitchell.
Good morning.
Mr. Mitchell, you're before the court this morning on a misdemeanor capias. This is related to a municipal ordinance violation for possession of drug paraphernalia. I find probable cause, and your attorney, Mr. Shate, is with me here in the courtroom. And Mr. Shate, what are we doing in Mr. Mitchell's case?
It'd be a time served offer, Judge, for the city.
All right, Mr. Mitchell, if you want to resolve the case today, the city's offer to you would be an adjudication of guilt with time served. Do you understand that?
Yes, ma'am.
Do you wish to accept that offer this morning?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Mitchell, do you understand everything we discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
Not at all.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I do.
All right, and Mr. Mitchell, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
Yes, ma'am. You have a good day.
You too, thank you.
Go out. Yeah.
On page 10, Kelvin Hunter. Good morning, Mr. Hunter. Mr. Hunter, you're before the court this morning on a misdemeanor capias. This is related to a municipal ordinance violation for possession of alcohol in a city park.
They've
I
they've
find-
offered time served, Judge.
All right, I find probable cause. If you want to resolve the case today, Mr. Hunter, the city's offer to you is an adjudication of guilt with time served. Do you understand that?
Uh-huh,
Do you wish to accept that offer this morning?
yes.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. Mr. Hunter, do you understand everything we've discussed so far this morning?
Yes, I do.
All right, is anyone forcing you to resolve this case?
Nah.
Are you under the influence of drugs or alcohol?
Uh-uh.
Do you need any more time to speak with your attorney?
No, I don't.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No, I haven't.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I do.
All right, and Mr. Hunter, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence is an adjudication, time served. Good luck to you.
All right, thank you.
You're welcome. Next is Michael Finn on page 11.
He'll be medically reset again, Judge.
I was going to ask if he is or not. He's
It
med-
is a medical reset.
All right, thank you. And our last demo case will be Christopher Terrientis on page 13.
Judge, that's
Oh,
actually,
that's not an MO case.
that's actually a felony matter I have with
Oh,
Mr.
you're handling
Terrientis.
this? Okay,
He's coming up now, I see.
okay.
He's here?
Thank you. Good morning, Mr. Terrientis.
Good morning, Judge.
Mr. Terrientis, you're before the court this morning on 3 charges. Each of these is a felony probation violation with a no bond hold. I find probable cause, and Mr. Terrientis, you're going to have a hearing with your division judge tomorrow morning to address the BOP issue. Do you understand?
I understand, Judge.
All right, good luck to you, sir.
Thank you, Judge. Chris, I'll see you tomorrow, okay?
All right, thank you. Okay, Mr. Romero, is Mr. Butler there yet?
He's approaching, Judge.
Thank you.
There's your private counsel right there, bottom center, okay?
All right. Good morning, Mr. Butler. Mr. Butler, you're before the court this morning
Press the button.
on 12 charges. Counts 1 through 4 are each a separate charge for DUI manslaughter. Counts 5 and 6 are each a separate count for vehicular homicide. Counts 7, 8, and 9 are each a separate count for DUI with damage to property or person of another. Counts 10, 11, and 12 are each a separate count for reckless driving with damage to person or property of another. I find probable cause for these charges. Your private counsel is present in the courtroom with me, and at this time, I will hear from the parties.
Thank you, Judge. If I can just briefly kind of summarize where we're at by way of explanation. The state in this matter filed a motion for pretrial detention over a week ago. We coordinated that hearing because there were a number of out-of-state witnesses that needed to fly in that were crucial to the testimony, and so it's set for this coming Friday in front of the presiding judge, Judge Duffy. So that pretrial detention motion will be heard on Friday. I think both parties, I spoke with Mr. Weiner, we agree that that matter will not be addressed today, so really the only issue to be addressed today is where Mr. Butler is residing from now until Friday, and whether or not he's in custody or at home with his 2 children and his wife and mother-in-law who are also here. Judge, my position is that just about a week ago, Mr. Weiner, who's been great in helping coordinate matters and sending discovery, joint emailed all of us, meaning the defense counsel and the judicial assistant,
Yes.
asking for this matter to be set for an in-court surrender and pretrial detention hearing on Friday. So he was picked up unexpectedly yesterday, not for any violation whatsoever, just a warrant check, which came up because of the not in custody capias. So all I'm asking Your Honor to do is honor essentially the state and defense agreement when Mr. Weiner emailed the JA a week ago asking for an in-court surrender. We would stipulate to level 1 pretrial, not to leave for any purposes, solely for him to be able to spend time with his 15-year-old and 17-year-old children before the pretrial detention hearing, whereby he may well be in custody for literally decades from here forward. And I would just add that as far as any potential concern this court may have as to whether or not it's safe to place him on level 1 from just now until this Friday, Mr. Butler, when knowing that these charges were about to be filed, was in Texas. He had traveled to Texas to get married. He was literally probably miles from Mexico, a number of other places. He literally came back specifically to answer to these charges. So he is not remotely a flight risk. He has proved that even in the course of the recent few months. He's just asking that we honor the state's agreement for a motion for in-court surrender on Friday, and he will stipulate to level 1.
Good morning, Your Honor. Ross Weiner on behalf of the state. Did Your Honor have a chance to review the lengthy motion? Sorry for dropping it so early. So early this morning. We didn't know he was going to be here. Your Honor, I would ask the court to abide by Rule 3.132(1)A, which states that if the motion for pretrial detention is facially sufficient, the judicial officer shall determine whether there is probable cause that the person committed the offense, which I know the court has found. And the rule allows the court to detain the defendant in custody pending a final hearing on pretrial detention, which must be held within 5 days. So all I'm asking the court to do is to hold him no bond on counts 1, 2, 3, 4, 5, and 6. The other bonds can remain as they are, and we'll have that full hearing before Judge Duffy, where she will have a full evidentiary hearing, and she will determine whether to hold the defendant without bond while the case is pending or give him a bond. That's what I would ask the court to do.
And my brief response is the rule is permissive. Certainly you have the authority. No one's arguing that you don't have the authority to hold him until Friday. The question is when the state themselves emailed the presiding judge asking for a motion for in-court surrender on Friday, and the defendant has shown by coming back from literally miles from the border to answer to these charges, is it appropriate to hold somebody in custody no bond when the deal that the state tried to arrange was for him to show up on Friday because they knew he would show up on Friday?
Well, I'm not sure that the state inquiring as to whether he would agree to an in-court surrender would amount to making a deal that he remain out of custody until Friday necessarily, in light of the hearing that was attempting to be coordinated. In this matter, we're addressing an accident that occurred in December of last year. Where does Mr. Butler actually reside?
He resides in the city of Coconut Creek, yes. And he would literally be on level 1 with no work, no anything, and a monitor, and he has no passport, just so Your Honor is aware. No passport at all.
I understand that the circumstances are unfortunate in light of the fact that he was picked up yesterday while the parties were trying to coordinate the hearing for Friday. But the fact is that he is in custody now and is facing some very serious allegations. And I'm not going to go into the details that are involved in these allegations, as I'm sure you're both aware of them. But as you said, counsel, I mean, depending on what happens with this case, he's potentially facing some very serious penalties. Has the hearing been set in front of Judge Duffy on Friday?
Yes, Your Honor, it's already set. It'll be held on Friday at 9 a.m.
Okay. Today is Tuesday. Since the hearing is already set in front of Judge Duffy and she will be his division judge, I think that she is going to be the person in the best position to decide ultimately what's going to happen with Mr. Butler while these charges are pending. For the time being between now and Friday, I believe that based on the allegations that I'm seeing, it would be best for me to grant the state's request and hold him in custody and let Judge Duffy address the matter. I don't know if she has any time slots earlier than Friday, but if not, at least you know that on Friday, he'll be able to address whatever these issues are. All right? So at this time on counts 1 through 6, he'll be held no bond, and I will leave the bonds in place on the remaining counts.
Thanks, Judge.
Thank you, Your Honor.
Thank you. Good luck, everyone. Mr. Weiner, do you want this copy back? I don't need the paper.
Thank you.
You're welcome. Thank you. Thank you very much. All right. Okay, I have another case to be taken out of turn. I'm not sure if he's present at the main jail. This was reset from yesterday. Jean Baptiste. He's on page 23.
Judge, he is here, he's present, I've spoken to him, we're ready to proceed.
Okay. All right, and I believe that yesterday, defense advised that you were waiving a formal reading of the charges?
Correct, Judge.
All right.
Correct.
For the record, I do find probable cause with relation to the two charges that are pending. And Mr. Linder, go ahead.
Yes, thank you, Judge. And yes, this matter was reset from yesterday, as I advised the court to provide an additional report from from, what's that? From Detective Ramirez. That has been provided. I provided a copy to the defense counsel. Based on the arrest warrant and affidavit and supplemental report, I'm going to be asking the court to make a finding of proof evident or presumption great on both counts 1 and 2. I understand that Judge Tobin Singer set a $100,000 bond on count 2, but the state would be requesting no bond holds on both counts. Your Honor, this is based on the allegations made by the alleged victim, certain admissions made by the defendant that are contradicted by testimony taken from the victim's mother, and also inconsistent statements that Mr. Jean Baptiste made to law enforcement.
Okay. Mr. Miller, defense's response.
Judge, I would just call the court's attention to the fact that the results from the examination are pending. That Mr. Jean Baptiste did report to the police department and make a voluntary statement, none of which implicates him in the crimes for which he is charged. I would also point out some contradictory statements made by the alleged victim, an 11-year-old child who, according to Mr. Jean Baptiste, was denied a request that she be taken to a party later that day. She indicated that, or it's indicated in the arrest affidavit that he was residing at this home for 2 months prior to the alleged incident. However, during the interview, the alleged victim says that this has been going on for 2 years and that it has happened 20 times. There is the fact that there are no results to corroborate her allegations. I would argue that there is no proof evident presumption great at this point, and ask the court to set a reasonable bond in this case.
If I may, I would just note there's nothing that Mr. Miller stated that there was any contradiction in the victim's statements. Just because there were other incidents that occurred past the time he was living with them isn't contradictory. He lived at another residence in Fort Lauderdale, Your Honor, so that doesn't contradict anything. Mr. Jean Baptiste explanation about the birthday party, that's not the victim contradicting herself in any of her statements.
But the reason I brought that up, Judge, is it gives now a motive for this young alleged victim to make up a story in order to punish this gentleman for a crime that may not ever have occurred.
All right. I have read both the probable cause affidavit as well as the supplemental report that was provided to me today. These are obviously extremely serious allegations that have been made by the alleged victim in this case. I am aware that Mr. Jean-Baptiste, in his statements to law enforcement, he's obviously denied the allegations. And I do note that the DNA testing is pending. I haven't received any results from those tests.
It's also a finding that there was, the allegations actually took place, that there was actual, well, I'll let the court fill in the next word.
What I'm saying is that the DNA testing is pending. I don't have any results back. If I had results back that had been matching, then that would bring us to a different level, obviously. Based on the statements that have been provided within the probable cause affidavit, which are obviously conflicting between the victim and her mother and Mr. Jean-Baptiste. At this time, the court is not going to make a preliminary finding of proof evident presumption great. However, I will hear recommendations from the parties as to bond and release conditions.
Refer to Mr. Romero.
Well, Your Honor, I'm going to be requesting a $150,000 bond on count 1, pretrial release of the GPS monitor level 1. You have found probable cause for two, well, at least one capital offense, Your Honor, where he's been accused of sexually assaulting or molesting an 11-year-old. Actually, she's 11 now, so it would have been between the ages of 9 and 11, 20 times. When confronted with this, he didn't stay and defend himself to the victim's mother. He ran. He fled from the home. That shows a consciousness of guilt. He admits to sleeping and going into a bed with an 11-year-old. His explanation was he does it often, sometimes with the victim's mother present. An allegation that under oath she denies that he's ever been in the bed with her and her child while she was present. And then lastly, when asked about the circumstances in which the victim left the bed when he was present, admittedly present there with her, he contradicts himself. He gives one explanation, and then when confronted with some more information, then he gives a different explanation of the circumstances in which he left the bed.
All right, Mr. Romero?
Judge, I just advised Mr. Jean what happened procedurally. At this time, I did advise him of the state's request, I believe, of a total of $250,000, $250,000 in bond. That's something Mr. Jean-Baptiste cannot afford. He's 47. He works, Judge. He lives with his mother. Where they rent, they do not own. I believe his share of the rent, from what he advised me, is about $350,000. The only person that's going to possibly help him with monetary bond is his family. And my understanding is, I believe she's a dishwasher. Can't come up with hardly anything, Judge. Now, Mr. Jean did advise me he has one asset. He owns a 2004 Honda Pilot with approximately 200,000 miles on it. He advised me that the resale value he believes is about $2,000. So the only thing to his name, 2004 Honda Pilot. He has no money in the bank. We're going to be asking on count 1, Judge, for a $50,000 bond, and on count 2 for a $25,000 bond.
Your Honor?
Yes.
Just some information I'd like to bring to the court's attention. And first, I apologize. I also meant to ask that Mr. Jean-Baptiste surrender his passport to the clerk of court prior to his release. I want the court to be aware, since Mr. Ramirez is advising the court that he lives with his mother, I was advised by Detective Ramirez that his mother also babysits the victim in this case. She has had contact with his mother and was given no indication. That's been an arrangement. That's an arrangement that's been going on the victim's entire life and was given no indication that that is going to not continue.
All right, in this case, on count 1, I'm going to set the bond at $150,000. I'm going to leave the $100,000 bond in place on count 2 that was previously set by, I believe it was Judge Tobin Singer. If Mr. Jean-Baptiste does post his monetary bond, he will be placed on pretrial supervision with a level 1 GPS monitor. There will also be an order of no victim contact. There will also be an order that Mr. Jean-Baptiste surrender his passport to the Broward County Clerk's Office prior to his release, and that he not apply for a new passport during the pendency of these proceedings. Mr. Jean-Baptiste, so that you understand the no contact order as it relates to the alleged victim in this case. The no contact order means you are not to be in the same place at the same time as this individual. Since you'll be wearing a GPS monitor, that will include a 500-foot stay away from her. The no contact order also includes no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes.
The only other request I would make is, since there's going to be a GPS monitor,
Yes.
which would require verification,
Yes.
if Mr. Jean-Baptiste advised he's going to be residing with his mother,
Yeah.
I would ask for part of his release condition be that pretrial confirms that his mother is not going to be babysitting the victim in this case, to avoid any potential for them being at the same location.
Separately, or can you include that on yours? Okay. All right, thank you. All right.
Your Honor, the Portuguese interpreter has arrived.
All right. Let me find that case. Okay, that's our interpreters here on the Roberto Amarin case.
Page 12, Judge.
All right, thank you. Sheila, you just need me to give this on? Raise your right hand. Do you swear or affirm to interpret from Portuguese to English and English to Portuguese to the best of your ability?
I do. Vera Jefremovas, J.E. Faria Movia, yes.
Thank you so much. All right. Good morning, Mr. Amarin.
Bom dia, Senhor Amarin.
You're before the court this morning on 4 charges.
O senhor está aqui perante a corte devido a 4 acusações.
Count 1, DUI, alcohol or drugs, first offense.
O primeiro fato, DUI, álcool ou droga, primeira ofensa.
Count 2, DUI with the blood alcohol level greater than 0.15.
Segundo fato, dirigir sob a influência com nível do álcool maior que 0,15.
Count 3, operating without a valid driver's license.
Fato número 3, dirigir sem uma carteira de motorista válida.
Count 4 is an immigration hold.
Fato número 4, tem uma detenção da imigração.
I find probable cause.
Eu julgo haver causa provável. Ok, e senhora juíza, ele também já pagou a fiança quanto às outras acusações.
All right, Mr. Amarin, I understand that your bond has been posted on counts 1 through 3.
Ok, senhora Marinho, eu entendo que o senhor, né, já pagou a fiança nos fatos de 1 a 3.
So that you understand on the immigration hold, that has a no bond hold.
Para que o senhor compreenda quanto essa detenção da imigração não é afiançável.
That means that you will go before an immigration judge in order to address that matter.
Isso significa que o senhor vai precisar comparecer perante o juiz de imigração para resolver esse assunto.
Do the parties wish to be heard on anything further?
Ok, quanto às partes, gostariam de dizer algo mais?
No, Judge.
Not at this time, Judge.
Não, senhora juíza, não nesse momento, senhora juíza.
All right, good luck to you, Mr. Amarin.
Ok, senhora Marim, boa sorte pro senhor.
Is there anyone else that needs a Portuguese interpreter while I have her here?
Tem mais alguém que precisa ajuda da intérprete para o português, já que ela está aqui presente?
Not at Maine, Judge.
Okay, don't rush. Don't come. It's okay. This is where you needed me to sign, right? Yes. Okay. Thank you so much. I appreciate you being here. Have a good one. All right. Going down our list, next will be Natalia Johnson.
She's approaching, Judge, here at Maine. Come on up, ma'am.
Thank you. Good morning, Ms. Johnson.
Good morning.
Ms. Johnson, you're before the court this morning on 2 charges. Count 1, possession or use of drug paraphernalia. Count 2, trespassing or failing to leave property upon order by owner. I find probable cause, and I will hear from the parties.
Judge, in speaking, Ms. Johnson, she wishes to resolve this matter. She wanted to see if the state had a plea offer for her today.
Okay.
Be adjudication time served.
So adjudication time served. There will also be a no return order to the 7-Eleven.
She wishes to accept the state's offer, Judge.
All right, Ms. Johnson, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Ms. Johnson, do you understand everything that's been discussed here this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and Ms. Johnson, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Ms. Johnson, your sentence will be an adjudication, time served, and there will be a no return to the 7-Eleven that's at issue in this case. Do you understand that?
Yes, ma'am.
All right, good luck to you, ma'am.
Thank you.
Lataya Sinclair.
Judge, she's approaching. She declined the service as public defender.
Okay. Good morning, Ms. Sinclair.
Good morning.
Ms. Sinclair, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes.
And are you declining the services of the public defender at this time?
Yes.
Okay. For the record, Ms. Sinclair, you're before the court this morning on 1 count of touch or strike battery. I find probable cause. Is the state seeking anything beyond the standard bond in this case?
Your Honor, if, just reading the circumstances of the case,
Yes.
I would really leave it up to Ms. Sinclair. If she would rather post the bond, I'm fine with that. If she would prefer a pretrial, I wouldn't have an objection to release the pretrial with
All right.
no victim contact.
Ms. Sinclair, I'm going to give you 2 choices, and you tell me which one is best for you, all right? Right now, your monetary bond is $1,000. I will either leave that in place and let you post the bond, or if you would prefer, I can waive the monetary bond and release you to pretrial supervision. That means you would have to report to them and abide by whatever reporting conditions they put on you. Do you understand that?
Yeah.
Which one,
Yes.
what would you prefer to do?
I'll keep the bond.
Okay, all right. Then, Ms. Sinclair, I'll leave the $1,000 bond in place. There will be an order of no victim contact. That means no being in the same place at the same time as this person. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with her. Do you understand?
Yes.
Okay, thank you very much. Good luck to you, ma'am.
One hit, one, then one hit.
Camilla Joseph.
Paul Ryan, Judge.
Thank you. Good morning, Ms. Joseph.
Good morning.
Ms. Joseph, you're before the court this morning on 4 traffic capiases. These are related to charges for driving with a suspended license, and the last 2 are also for driving with a suspended license. I find probable cause. Do the parties wish to be heard?
Judge, I talked to Ms. Joseph this morning and advised her that this court would probably not be addressing the bonds and that she would be seeing her judge tomorrow.
Okay.
I've been advised by her bondsman that he's posting.
Her bondsman is posting the bonds? Okay. All right, so I will leave the standard bonds in place as they have been set. Good luck to you, Ms. Joseph.
Thank you.
You're welcome. Allison Williams.
Medical reset.
Okay. Stephanie Brown.
Ms. Brown allegedly refused to come to court this morning.
She was a medical reset yesterday, wasn't she?
Was, Your Honor, what I would ask at this point, if the court can make a probable cause determination, you can either have a reset for bond or she'll be on the second look docket if she doesn't post.
All right. Okay, I'm going to make a finding of probable cause in absentia, and I'll just have her reset for bond. We'll see if she posted or not. All right. Merlandi Pierre.
Your Honor?
Yes.
I don't know where the issue lies, but the officer's intent was to charge her with 2 counts of assault on a law enforcement officer, not aggravated.
All right, I'll cross out aggravated. Can someone at Paul Ryan turn the speaker off there, please? All right. Good morning, Ms. Pierre.
Hi.
You're before the court this morning on 4 charges. Counts 1 and 2 are each a separate count for assault on an officer. Count 3, resisting an officer obstructing without violence. Count 4 is a misdemeanor capias, and that is related to a violation of an injunction. I find probable cause, and I will hear from the parties. Ms. Pierre, 1 moment, please.
Your Honor, considering that she was already out on an injunction that she failed to appear in court, I'd be requesting a $250 bond each on 1 and 2.
All right, will someone call Paul Ryan and please tell them to turn their speaker off? Thank you. All right, Mr. Miller, I'll hear from you.
Judge, Ms. Pierre has been living in South Florida her entire life. She's been at the same location for the past 5 years. She is disabled. She's not receiving any disability payments. Her boyfriend is supporting her. She believes she can afford $200 total. So I would ask the court to ROR her on counts 1 and 2.
Just to advise the court. She was also arrested in Broward 2018 for failing to appear in a battery case. She's had out-of-county holds on more than 1 occasion for failing to appear in court, and has had multiple battery or domestic
I
violence.
was in the hospital.
Ms. Pierre, please, just listen, just listen.
Multiple domestic battery arrests in the past.
All right, Ms. Pierre, I want you to listen carefully what I'm saying. I'm not addressing anything about the facts or background of the case today. We're only talking about bond and release conditions. Do you understand? All right, is there something you want to tell me about bond only?
Can I just get bond for 200 because that's all I can afford right now.
All right, well,
And
I'm gonna tell you right now that on count 4, that's the capias. Your division judge has already set a $1,000 bond on that case. So I'm not gonna change that because that was set by a different judge. And you'll have a hearing with that judge tomorrow morning.
Okay.
All right.
So what's going on with the other?
I'm gonna tell you in just a moment. Okay, on the counts 1 and 2, I will set the bond at $100 for each of those counts, and I'll leave the $100 bond in place on count 3.
Thank you.
All right. Ms. Pierre, you'll see your division judge tomorrow morning on the other case, okay?
Okay, thank you.
Good luck. Courtney Smith.
And she's at North Broward, Judge.
Good morning, Ms.
Hi.
Smith.
Good morning.
Ms. Smith, you're before the court this morning on 2 charges. Count 1, DUI, alcohol or drugs, fourth or subsequent offense. Count 2, child neglect without great bodily harm. I find probable cause for these charges, and I will hear from the parties at this time.
So, Judge, in light of the fact that Ms. Smith blew 000s twice, she was found asleep in her car, not driving. I would ask the court to consider releasing her on her own recognizance. She did give a urine sample. That is pending. And I would just ask the court to release her on her own recognizance.
Your Honor, Mr. Miller and I may have a slight disagreement about the finer points of the allegations. I would say that Ms. Smith was found passed out in her vehicle. Also,
Ms. Smith, not the time. Please just listen.
also with her 3-year-old in the back seat. Anybody could have come to that vehicle at any time while she was passed out or asleep and taken that child. The car was running. Who knows what could have happened? This is her 4th DUI. She is...
Ms. Smith, I'm going to say it one more time. Please remain silent. This is a time for you to listen. I'm hearing from the attorneys. Please continue, Mr. Linder.
Thank you, Your Honor. I would say it's not surprising that she blew 0. The officer even mentions as the indicators of impairment. He never even mentions odor of alcohol. It would seem to indicate that she was under the influence of some type of drug or controlled substance, which from a urine test, unfortunately, they cannot get results that quickly. But I don't think that in and of itself, taking all the other evidence, the indicia of impairment, should result in her in an ROR. I do believe she poses a danger to other drivers in the community, and based on these allegations, a danger to her own child. I'm requesting a $5,000 bond on count 1, a $2,500 bond on count 2. Should she post her bond, that she be supervised by pretrial, no victim contact, random testing, no alcohol or intoxicants, TAD monitor, and no driving until further order of the court.
Okay. So Ms. Smith has been living in South Florida since 1996. She's been at her current address for the past 3 years. She works for a private equity firm in Boca. The child today is with her uncle. Dad is unavailable. The family will assist if the court requires, as far as providing guardianship for the child. However, I would ask the court to consider a lower bond if you're not going to put her on pretrial, $1,500 per count, and allow her to have contact with her child. If the court wants to put her, I guess a TAD monitor is not the issue here, but she can be put on random testing.
I do just want to note, since there's been some discussion about this today, that though the the breath test, she blew .000s, in her questioning and answers provided to law enforcement, it seems that she did admit to taking both Adderall and Xanax. Whether that appears in the urinalysis that comes up later, obviously that's not going to be for this court to deal with. But given the history and the present allegations, it's obviously very concerning when taken in totality. All right. In this case, on count 1, I'm going to impose a $2,500 monetary bond. On count 2, I'm going to impose a $1,500 bond. Should Ms. Smith post her monetary bond, she will be placed on pretrial supervision. She will be subjected to random testing 1 time per week. Ms. Smith, that means no alcohol, no intoxicants until further order of the court. I'm not going to impose the tab monitor at this time. There will be an order that Ms. Smith not be driving any motor vehicle until further order of the court. And at this time, I am going to impose an order of no victim contact as it relates to the minor child.
Okay, Judge,
Yes.
okay, and that'll be fine. She could provide prescription, if she can provide prescriptions to pretrial, then those, whatever substances those are not to be excluded. Is that correct?
As long as she's complying with whatever those prescription dosages are. All right, Ms. Smith, do you understand those conditions of release?
Yes.
All right, thank you very much.
Thank-
Do you want me to
Okay.
go over them one more time?
Yes, please.
All right.
Can you reconsider the no contact with my daughter as long as the family has her and I'm...
Ms. Smith, in light of the circumstances right now, I'm going to leave that order in place to know that she's with family and she's safe right now, then that is
I
good.
hope she is. I hope they didn't lie to me. Did
Okay,
they lie to me?
okay, Ms. Smith, the no contact order, if that needs to be revisited, your attorneys can file the appropriate motion with the division judge to handle it later on. But for now, I need you to understand that that no contact order will be in place, all right?
Okay, okay.
Okay, I'm gonna go over these one more time so that I know that you understand, okay? You have 2 counts. Count 1 is the DUI count. The bond is going to be $2,500. Count 2 is the child neglect count. The bond is going to be $1,500. If you post the monetary bond, then you will be placed on pretrial supervision. They are going to randomly drug and test you. They're screening you from drugs and alcohol once a week, all right? Additionally, you are not to be driving any motor vehicle until further order of the court, and the no victim contact order that we discussed is in place. Do you understand all of that? Okay, all right, thank you. Good luck. Chantrell Martin.
Name.
Thank you. Good morning, Ms. Martin.
Good morning.
Ms. Martin, you're before the court this morning on 1 charge of driving while license suspended, habitual. I find probable cause, and I will hear from the parties.
Judge, nothing to request. I'm going to be contacting Ms. Martin's boyfriend to post a bond.
All right, anything further from the state?
No, Judge.
Okay, I'll leave the bond in place. Thank you. Justin Collins.
He's approaching Judge May. Come on up, sir.
Good morning, Mr. Collins.
Good morning, Judge.
Mr. Collins, you're before the court this morning on 2 charges. Count 1, touch or strike battery, domestic violence. Count 2 is for obstruction, depriving of means to protect or communicate. I find probable cause, and I'll hear from the parties.
I would just argue that the alleged victim in the case did in fact call 911. I don't see where the removal of the cell phone exists other than this in the summary.
It says in the second paragraph on the second page of the probable cause affidavit, the last sentence, defendant Collins grabbed her cell phone as she was speaking to dispatch and attempted to discontinue the phone call. All right, I'll hear the parties' recommendations as to bond and release conditions.
Your Honor, one moment. I'm just checking to see if there's any history. If
Okay.
Mr. Romero wants to proceed, that's fine with me.
Mr. Romero, if you want to go first, go ahead.
Judge, Mr. Collins is working. He just got a job a couple months ago at Hardgrass Construction. He's 30 years old and living in our community for the past 3 years. He'll be finding a separate place to live because he currently lives with the alleged victim. I did tell him that it's going to be a no contact order, so he will be abiding by that order. Judge, I'm going to be requesting a $1,000 bond on count 1, a $1,000 bond on count 2 on Mr. Collins' behalf.
Your Honor, I see prior arrests, but they were all dropped, so it would appear there's no history of convictions or withholds. Your Honor, I'm going to be asking for a $1,000 bond on 2. I'd be requesting a $2,000 bond on 1. Just noting, Mr. Collins is alleged to have struck or put his hands on the victim more than once. The first time, striking her in the mouth while she was driving. And I would be requesting no victim contact.
The bond on count 1 will be set at $1,500. The bond on count 2 will be set at $1,000. There will also be an order of no victim contact. Mr. Collins, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. The no contact order also includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that, sir?
Yeah, I'm moving out and I cannot wait fast enough.
All right, thank you, Mr. Collins.
Oh, Judge, a photo order as well.
That's fine, I'll sign that. Bernard Lessie.
It's a medical research.
Mr. Medical.
Izoan Prince.
Please approach the judge. Come on up, sir.
Good morning, Mr. Prince.
Good morning, young.
Mr. Prince, you're before the court this morning on an ad charge. This new charge is related to a misdemeanor capias on a charge for possession of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Judge, I believe Mr. Prince has several no bond holds, so nothing to request at this time, Judge.
All right. I will leave the $100 bond in place then. Thank you. Good luck, Mr. Prince. Vernon Coleman.
Mr. Coleman, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Coleman. Mr. Coleman, you're before the court this morning on 2 charges. Count 1, possession or use of drug paraphernalia. Count 2, trespassing on property, not a structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, Mr. Coleman wishes to resolve this matter. We wanted to see if the state had a plea offer for him today.
Yes, the offer would be 15 days in county jail. This is his 14th arrest in the past year. He was just, Judge Gottlieb was gracious enough to ROR him on February
Judge,
9th.
respectfully, Mr. Coleman's declining the state's offer.
All right, I'm gonna leave the $100 bond in place at this time. There will be an order of no return to this location, which I believe is a West Star gas station.
Your Honor.
Yes,
Judge, I
Mr.
believe
Coleman.
Mr. Coleman wants to address the bond. He can't afford
I
it.
can't afford the bond. Now, that's number one. Number two, I have to be at a funeral.
That is why Judge Gottlieb ROR'd Mr. Coleman on the 19th. They told him he just had to come back to court this Friday.
Yeah, exactly.
And
Judge,
the
would the
funeral,
court be
according to the
open to pretrial release?
Well, I'm a little concerned now because
Go
according
ahead.
to the order, Judge Gottlieb wrote the funeral was on February 20th.
I'm leaving the bond in place with the no return order. Thank you. Luis Gonzalez.
Mr. Gonzalez, come on up. He's approaching, Judge.
Thank
Come
you.
on up, Mr. Gonzalez.
Good morning, Mr. Gonzalez. You're before the court this morning on 1 charge of first-degree petty theft. I find probable cause. I'll hear from the parties.
Judge, Mr. Gonzalez wishes to resolve this matter today.
Is there an offer?
Your Honor, the offer would be 7 days in county jail. He's got open cases in Dade and Palm Beach right now, at least one for theft. He has a lengthy history out of the state of Texas. I see at least one prior for aggravated robbery. Some diversion for something. No, I don't think so anymore. I don't think so. I swear. It's a benchmark. Look at his hot file.
Judge, at this time, Mr. Gonzalez, I did advise him what's the state offer. I did advise him, since he has other matters pending in different jurisdictions, this could impact him. I could not answer his question because I do not know what he has going on in different jurisdiction. He doesn't know what to do at this time, Judge.
Okay, then I'll leave the bond in place, and he can either post the bond and discuss it with his attorneys further so that he can find out what's going on. Thank you. John Lampkin,
North Broward, Judge.
is it a
Reset,
medical,
Judge.
medical reset? Okay, thank you. Jimmy Neal.
Conti, Jimmy Neal.
Thank you. Thanks, Deputy.
Welcome, ma'am.
Good morning, Mr. Neal.
Good morning, Judge.
Mr. Neal, you're before the court this morning on 3 ad charges. Count 12 is for robbery with a weapon. Count 13, aggravated battery with a deadly weapon. Count 14, sexual assault with a weapon, victim over 12 years of age.
12 years of age.
Mr. Neal,
Mr. Neal, you probably want to refrain from talking.
Oh, I'm sorry. No, just.
I find probable cause for these charges, and at this time, I will hear recommendations from the parties as to bond and release conditions.
Judge, in light of the no bond holds, we're not going to be making any arguments today.
All right, what's the state's recommendation?
On 14, I'm going to be seeking a finding of proof evident, presumption great, that Mr. Neal be held no bond on that count. Just noting the statement provided by the alleged victim, the DNA evidence, and her identification of Mr. Neal. On counts 12 and 13, while it may be a moot issue, Your Honor, a bond does have to be set, and I think the court should be aware, in addition to these charges, he is being held on 5 other counts, or separate charges of sexual assault with a weapon, aggravated assault with a deadly weapon, 4 counts of armed kidnapping, Your Honor. So in light of that, I'd be requesting $100,000 bonds on counts 12 and 13, and in order of no victim contact and an abundance of caution.
Just for the record, since it seems there are other similar pending charges against Mr. Neal, this is related to incident that allegedly occurred on July 23rd of 2019.
And Your Honor, if I may?
Go ahead.
Just to, in case there's any issues, to specify.
Yes.
It deals with offense report number 33-1907-97493.
At this time, the court is going to make a preliminary finding of proof evident, presumption great, in order that Mr. Neal be held no bond on count 14. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter. On counts 12 and 13, the bond will be set at $100,000 per count. There will also be an order of no victim contact.
Excuse me, Judge.
Yes, Mr. Neal.
The bond you said that set at 100,000. That's for which?
Mr. Neal, does it
Yeah.
matter? You're being held without bond. Does it matter how much the bonds are on two of the counts?
Okay, it's not
Okay.
true.
Talk to your attorney.
All right.
Yes,
I'm sorry. What was that, Sheila? 14. Yeah. 12 and 13 are $100,000 each. 14 is a no bond hold. And Mr. Neal, you'll be able to address this with your attorney and with your division judge at a later date. All right?
Okay.
All right. Thank you.
You're welcome.
Barry Wimbush. Is he at Maine?
No.
Morning, Mr. Wimbush.
Morning, Judge.
Mr. Wimbush, you're before the court this morning on one charge of grand theft auto. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Winbush's mother
Okay, anything
to
to
put
say?
his bond.
All right, I'll leave the standard bond in place. Good luck, Mr. Wimbush. Jason Douglas Clay Willis.
He's approaching, Judge.
Thank you. Good morning, Mr. Willis.
Good morning.
Mr. Willis, you're before the court this morning on 3 charges. Count 1, second-degree petty theft, third or subsequent offense. Count 2, possession of cocaine. Count 3, possession or use of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Judge, nothing to request at this time.
All right, anything from the state?
No, Judge. Just
Okay.
no return to.
All right, there's gonna be a no return order to the Walgreens at 700 West Broward Boulevard. Mr. Willis, you understand that?
Yes, ma'am.
All right, thank you. I'll leave the standard bonds in place. Dominic Snell,
He's approaching, Judge. Maine.
thank you. Good morning, Mr. Snell.
Morning.
Mr. Snell, you're before the court this morning on 2 charges. Count 1, possession of fentanyl. Count 2 is a felony probation violation with a no bond hold. I find probable cause. I do see Mr. Snell has a hearing with his division judge tomorrow morning on the VOP. In light of that, do the parties wish to be heard on count 1?
No, Judge.
All right, that bond will remain in place. Thank you. Patrick Adams.
Sell about the corporation keeps it. I guess you can.
He's approaching, Judge.
Thank you. Good morning, Mr. Adams.
Good morning.
Mr. Adams, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied dwelling, unarmed. Count 2, first-degree petty theft. I find probable cause, and I'll hear from the parties.
Judge, and speaking to Mr. Adams, unfortunately, at this time, he advised me he's financially indigent. He's basically 28 years old. He's currently looking for employment. Unfortunately, at this time, he's basically homeless, Judge. He can't afford anything. My understanding is I believe he has a clean record. He did advise me he has prior contact with criminal justice system, but he believes they were dropped. Having said that, Judge, he doesn't believe no one can afford to post his monetary bond. So, Judge, he's requesting pretrial release. If not, Judge, we're going to be asking for a minimal amount of bond of $3,000 on Mr. Adams' behalf.
Your Honor, I'm going to be requesting a $10,000 bond. First, just on the nature of the charge alone, he and a co-defendant broke into someone's home. On top of that, it would not only appear he has no ties to the area, but he is transient. As you can see on the booking sheet, it shows a Jacksonville address. Then on the PC affidavit, an at-large address in Dania. He's got an active warrant right now. It's not extraditable, but it is a warrant from 2017 for failing to appear in court, and that's out of New Mexico. I'm showing that he was arrested in Duval County on last year on another out-of-county warrant. The point being is history shows that, like I said, he would appear to be transient, and I don't know, and my concern is facing a second-degree felony might be cause for him, since there's no reason for him, from what Mr. Romero is stating, to stay in Broward or South Florida, period. I think there needs to be a proper incentive to ensure he returns to court to face this second-degree felony.
All right, I'm gonna set the bond on count 1 at $7,500. There's also going to be an order of no victim contact, as well as a no return order. Mr. Adams, so that you understand those orders, no return means you are not to return to the location this allegedly occurred at. With regard to the no victim contact order, whether you know the alleged victim or not, that means no being in the same place at the same time. That also includes no phone calls or text messages to that person, no third-party contact or social media contact with that person. Do you understand that?
Yes, ma'am.
Thank you. Jack Voltaire.
North Broward, Judge.
Thank you. Good morning, Mr. Voltaire.
Hello, Your Honor.
Mr. Voltaire, you're before the court this morning on 2 charges. Count 1, burglary of an occupied conveyance, unarmed. Count 2, criminal mischief between $200 and $1,000. I find probable cause, and I'll hear from the parties.
Your Honor, first, this would appear to be a burglary of a structure.
Yes. All right, I do see that. I'm going to make the correction on my finding sheet. All right, go ahead.
Let me check something. Your Honor, I'm going to be requesting a $15,000 bond on count 1 and a GPS monitor. First off, the court should be aware that Mr. Voltaire has 3 pending cases before Judge Porth in mental health court. One for attempted burglary of a conveyance, another for burglary of a dwelling and theft, and a third for tampering with evidence and trespass. The listed victim in this case, the owner of the Montessori school, from what I can tell, has already sought and obtained a temporary injunction, order of protection. My concern also is for the children that attend this school, as it is mentioned that Mr. Voltaire harasses not only the staff but the children as well.
That's right.
Mr. Miller.
Judge, as Mr. Linder indicated, Mr. Voltaire does have cases in front of Judge Porth. He's been living in South Florida for 10 years. He's currently receiving SSI. He cannot afford the bond that Mr. Linder is requesting. We were hoping the court would consider pretrial release since he's already on release from his felony charges in Judge Porth's division.
Just so the court's aware, Mr. Voltaire was arrested January 8th of this year on multiple warrants for violating pretrial from his cases in front of Judge Porth. I'm sorry, on December 24th of last year. He was ROR on January 8th of this year.
All right. Well, I'm not going to take any action to revoke his bond in the pending cases. But in this case, in light of these allegations and the history and other pending charges, I am going to impose the $15,000 bond. If Mr. Voltaire does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no return to the Montessori school that is at issue in this case. Mr. Voltaire, do you understand that you are not to return to that location?
Yes, Your Honor.
All right, and I'll let Judge Porth decide what to do with the other cases. Thank you.
All right.
Miguel Angel.
Maine.
Thank you.
Mr. Angel's approaching, Judge. Maine.
Thank you. Good morning, Mr. Angel.
Good morning.
Mr. Angel, you're before the court this morning on 2 charges. Count 1, driving while license suspended, habitual. Count 2 is a civil writ of arrest that is not for magistrate. It does have a purge amount of $1,197. I find probable cause, and I'll hear from the parties if they wish to be heard.
Judge,
Judge,
I don't
I
see
did
the-
advise Mr. Angel. Oh, sorry.
Go ahead, Mr. Romero.
Mr. Romero, go ahead.
Okay, I did advise Mr. Angel as far as the purge amount of count 2. On count 1, however, the $750 bond, I'm gonna ask for a property order so that he can self-bond. He believes he has about $300 in his property. I'm assuming they've already taken out, around $28, somewhere around there. So I'm gonna ask the court if the court would consider reducing the bond on count 1 to about like $260 on Mr. Angel's behalf so he can self-bond.
One moment, Judge.
While Mr. Linder is getting ready, just for the record, the civil writ of arrest is out of Marion County.
While I'm looking, Your Honor, I apologize. What is Mr. Romero seeking?
He's requesting that the bond on count 1 be reduced to $260 so Mr. Angel can self-bond.
Your Honor, I would object, if he wants pretrial, that might be more acceptable, but this involved a crash. He has prior convictions for DWS. I see he's had prior failures to appear.
Judge, then pretrial would be acceptable to Mr. Angel.
All right.
Frankly, I think 750 is still appropriate, considering it is a habitual and he was in a crash, but it's up to Your Honor. Why is his driver's...
All right. I will ROR him on count 1 to standard pretrial, and then he'll have to address the civil writ of arrest that's out of Marion County. All right.
Thank you, Judge.
Thank you. Good luck, Mr. Angel. I'm signing the property order in case he needs it.
Yes, sir.
Shaquan Roberson.
He's approaching, Judge. He's here at Main. Come on up, sir.
Thank you. Good morning, Mr. Roberson.
Good morning, Your Honor.
Mr. Roberson, you're before the court this morning on 12 charges. Count 1, burglary of an occupied structure, unarmed. Count 2, grand theft between $750 and $5,000. Count 3, resisting an officer, obstructing without violence. Count 4, burglary of an unoccupied structure, unarmed. Count 5, grand theft between $750 and $5,000. Count 6 is a misdemeanor capias. That is related to a charge for petty theft. Count 7, burglary of an unoccupied structure, unarmed. Count 8, second-degree petty theft, third or subsequent offense. Counts 9 through 12 are felony warrants for violations of pretrial, which have no bond holds and are not for magistrate. I find probable cause for these charges. I will hear from the parties on, at least on count 1. If they want to be heard on the remaining counts, then I'll hear argument.
Your Honor, I'm requesting a $15,000 bond on count 1. On count 7, the burglary on the arrest warrant,
Yes.
$15,000. Count 8, the felony theft, $5,000. Your Honor, the reason I'm making these requests is you can see he's already got some pending cases for the same offenses he stands before the court on.
Yes.
In that case, he was fortunate enough to be given a GPS monitor, which he tampered with, which is why he couldn't be located all this time. But the court should be aware that he has, in addition to those 2 cases, he has the following cases open as well. He has a open burglary of a structure, an open grand theft, an open burglary of a structure and theft, another case with an open 3 counts of burglary of a structure, grand theft, and petty theft, and another case, burglary of a structure and theft. So he has 1, 2, 3, 4, 5, 6, 7. He's got 9 open felony cases.
All
And
in
now he's
Broward?
here. I'm sorry?
They're all in Broward?
Yes, they're all in Broward. He wasn't on pretrial on all of them. That's why there's only 2 warrants for revoking his pretrial. But clearly, there's no reason to believe Mr. Roberson, if let out of custody, is going to stop committing burglaries. 2 cases.
Mr. Romero?
Look at the case numbers.
Judge, as you can see, he has no bond holds, and I believe he has other offenses that already have a bond on, which are similar in nature. Mr. Roberson advised me works at Burger King, only getting $9 an hour. Based on that, I'm going to be asking for similar bonds as currently set on the other offenses. On count 7, I'm going to be, counts 1 and 7, I'm going to be requesting a $1,000 bond each. And on the felony petty theft, I'm asking for the standard bond, which is, I believe, $750. So that's what I'm asking.
Rather than revoke his bond in the other cases that are all pending in Broward on similar charges, I am going to grant the state's request. Counts 1 and 7, bond will be set at $15,000 each. Count 8, bond will be set at $5,000. There will be no return orders in place. The charges that are before the court today relate to multiple locations. The no return order will apply to each of those separate locations. And Mr. Roberson will go before his division judge to address the no bond holds.
Yes, sir.
Thank you. Derek Gardner.
Mr. Gardner's approaching. He's here at Main, Judge. Come on up, sir.
Thank you.
At this time, I would invoke Mr. Gardner's right to remain silent, ask that he not be questioned by law enforcement outside the presence of his attorney.
Thank you. Good morning, Mr. Gardner.
Good morning.
Here before the court this morning on 2 charges. Count 1, second-degree murder without premeditation. Count 2 is an immigration hold, which has a no bond hold. I find probable cause for these charges. Before we address count 1, Mr. Gardner, so that you understand on count 2, since that has a no bond hold, you will have to go before an immigration judge in order to address that matter. At this time, I will hear from the parties with their arguments as to count 1.
Your Honor, the state would be seeking a finding of proof evident or presumption great, and ask that Mr. Gardner be held no bond on this punishable by life offense. Noting witness testimony, there is video evidence, Your Honor, and identification from multiple witnesses.
Mr. Miller, the defense's response.
Your Honor, other than arguing that the court should not find proof evident presumption great based solely on the hearsay affidavit, I have no argument to make at this time.
All right. I have reviewed all of the allegations included in the probable cause affidavit. Based on those allegations, at this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Gardner be held without bond as to count 1. This will be without prejudice for him to have the appropriate Arthur hearing before his division judge. Thank you. Rejanta Randall.
Judge, Mr. Randall's here present. He advises that he's going to be hiring private counsel. He's just wanting to see if if his bond's been paid.
Okay, I just want to say one thing. Confinement has just confirmed to me Mr. Randall is being charged with a violation of probation, which will have a no bond hold attached to it. But I will check to see if his bond has been posted as to this charge.
I spoke to his attorney. They were planning on posting it. They're aware from the jail that there was going to be a potential ad charge. I spoke with Ms. Olnor from Eric Schwartzreich's office.
Yes.
And when I discussed with her, we really couldn't address a potential VOP at this time.
Yes.
But if and when he does get out charged with it, obviously the matter could be discussed in court.
All right. Mr. Randall, good morning. Okay. I'm well. Mr. Randall, for the record, you're before the court this morning on a charge for carrying a concealed firearm. I do find probable cause. The bond that's set is $1,000. I have checked with confinement. The bond has not yet been posted. According to what Mr. Linder, the state attorney, has told me, he did speak with your attorney's office. They confirmed they will be posting that bond. They are aware that there was a potential that you would be ad charged with a violation of probation. So that will be, confinement has confirmed to me you are being ad charged with that. It's just not in front of me this morning. So we'll probably be addressing that either this afternoon or tomorrow morning. Do you understand that?
And the ad charges from what, me being interacting with the police?
It's a violation of probation. All right, so Mr. Randall, we'll address that when it comes up because it's not in front of me this morning, but it is coming. I just want you to be aware of it. So I'll leave the $1,000 bond in place at this time on this charge. All right? Good luck to you. Amandolfo Wright.
North Broward?
Thank you. Good morning, Mr. Wright.
Good morning.
Mr. Wright, you're before the court this morning on 5 charges. Count 1, grand theft auto. Count 2, operating without a valid driver's license. Count 3, improper change of lanes. Count 4, failure to use a designated signal or lane. Count 5, failure to wear a safety belt. Counts 3, 4, and 5 are not for magistrate. I find probable cause, and I'll hear from the parties as to count 1. Is the state seeking anything beyond the standard bond? Mr. Miller?
No objection.
All right, I will leave the $1,000 bond in place at this time. All right, good luck, Mr. Wright. Patrick Tanis.
Bonded.
Thank you. Nolan Reed.
Medical reset.
Okay. Joseph Suris.
Here in Maine.
Thank you. Good morning, Mr. Suris. Mr. Suris, you're before the court this morning on 2 charges. Count 1, grand theft auto.
Mike?
Count 2, operating without a valid driver's license. I find probable cause, and I'll hear from the parties.
Judge, Mr. Suris advised me no one's going to be able to afford to post his bond. He's 28 years old, been here his whole entire life. At this time, he's not employed, but he's looking for employment, and he advised me he's homeless. So we're asking to be released on pretrial release for Mr. Suris. And Judge, my understanding speaking Mr. Suris, he advised me he has no prior convictions.
Okay, Mr. Linder.
He's got a 2014 conviction for battery and trespass. He has other priors, but that's the first conviction I see. Showing on 7 previous occasions, capias has had to be issued for his failure to appear in court. The most recent arrest was in February 2018 for failing to appear in court.
At this time, I'm going to leave the standard bond in place. Thank you. Steve Miklos. Is he back from medical?
I think so. Check to see where he is.
Where is he supposed to be?
I'm sorry, that's a medical reset.
Okay, thank you. Taylor Wesson.
Medical.
Your Honor,
Did I make a probable cause finding in his case?
I don't know. I don't believe one was done. I would ask if the court would be inclined to make
Yeah,
a determination one way or the other.
In Mr. Weston's case, I did review the probable cause affidavit. I will make a finding of probable cause in absentia, and we'll have him reset for bond if necessary, because I do see that he has some VOPs. So if he hasn't already, I'm sure he will be going before his division judge. Radcliffe Barnett.
North Broward, Judge, I was told he was in courtroom 6870 this morning.
Okay, that's probably on his VOP. All right, we'll have him reset tomorrow. Anthony Malone.
Med reset, Judge.
Ask the court to make the probable cause determination. What?
Was Anthony Malone already reset? Oh, yes, he was. Okay. Did you say he refused or he was a medical reset? Okay. All right, on Mr. Malone's case, I will make a probable cause finding in absentia. We'll have him reset for bond. Taekwon Cheatham.
Conti, Judge, I looked this up this morning, and it appears that Mr. Cheatham had an arraignment this morning in front of his division judge.
Okay.
This is a change of charge capias, a second from a second degree to a second degree.
Okay.
The previous bond was $7,500. He was a PD client as of this morning. However, we filed a motion to withdraw it yesterday. And so I'm assuming, without knowing, that that was heard today in front of his division judge during arraignment. So I'm not even sure that I have any standing here.
Either way, Your Honor, I'd ask that the court put the $7,500 bond back in place, especially considering that he's already been arraigned by Judge Fine. I think any further bond modification should be heard by him.
Okay, that's fine. I will, since this is a lateral, I'll just replace the bond at 7,500, and Judge Fine can address any modifications. Joshua Santamoro.
North Broward Judge?
Thank you. Thank you. Good morning, Mr. Santamoro.
Good morning.
Mr. Santamoro, you're before the court this morning on a change of charge. And Mr. Linder, I just want to make sure this is correct. The original charge was battery on an officer, firefighter, or EMT, and it's just being changed to battery on a firefighter. Is that correct?
Yes,
All right. So what was the bond set at?
$2,500.
All right, Mr. Miller, any objection to me leaving the bond at 2,500?
None, Judge.
All right, then I'm going to, since this is just a technical change, Mr. Santamoro, I'm going to leave the bond as it was already set. All right, good luck to you, sir.
All right, thank you.
You're welcome.
So the charges are filed then?
I'm sorry, sir?
So the charges were filed then?
Yes, that's correct.
Same answer
Okay.
I gave you about
Thank
a half
you.
an hour ago.
All right, next
All
will
right, my
be,
bad. Have a good night.
thank you, good luck. Larry Andrews.
Judge, I'm told that Mr. Andrews is in 6810 this morning.
Your Honor, he's being arraigned
Okay,
on this case. He's being advised of the charges.
all right,
Now, it's a change of charge from burglary to attempted burglary.
yes.
I reviewed the original probable cause affidavit. It's clear in the allegations that the second count was an attempt.
Okay,
Your Honor still set the bond at $3,500.
okay.
I'd ask that you keep the bond at $3,500.
All right, Mr. Miller, any objection? All right, I'm going to, on my finding sheet, I'm just going to note that it is attempt because it's not on here. And I'll leave the bond at 3,500, or, replace it at 3,500. Benny Wimbush.
Mr. Wimbush is here at Main, Judge. He's approaching. Come on up, Mr.
Thank you.
Wimbush.
So Judge, this is a change of charge from structure to conveyance.
Okay,
The bond was set at $3,000 by Judge Barner on January 27th.
all right.
And Judge, that is correct. That's what Mr. Wimbush advised me. He's been in custody about a month or so, or less. But he advised me he's not in the process of being able to afford that $3,000. He said that's the only thing holding him. So he's asking if the court would consider an ROR. If the court's not comfortable with an ROR, he's asking if the court would consider releasing him under supervision of pretrial.
He was asked that the court keep the bond in place. He had a second look already. That was denied. He was arraigned yesterday by Judge Siegel, and he's got a calendar call date now.
All right, I'm going to leave the bond at $3,000, so I'll just replace that, and we'll leave it as it is. Thank you.
And Judge, Mr. Wimbush has advised me, I believe when he was here in second look, there was another case, and I believe no action was taken at that time. That other case now has been thrown out, so he's not in a similar standing. So he's asking, since this case is before you today, for an ROR or on pretrial.
I'm respectfully going to deny the request. Thank you.
Yeah.
All right, next will be William Freeman.
Conti, Judge.
Conti.
Thank you. This is a change of charge as well.
Yes, well, I'll
Let's wait for him.
Judge, it's from a child abuse charge to a second battery, a third degree to a third degree. The original bond was set by your Honor on February 4th at $2,500.
Is Mr. Freeman joining us today? Conti, do you have William Freeman? Thanks, Deputy. All right, good morning, Mr. Freeman.
Good morning.
Mr. Freeman, you're before the court today on a change of charge. The original charge was child abuse without great bodily harm. This has been changed by the state to battery, second or subsequent offense. All right, the original bond was set at $2,500.
Yes, Your Honor, I'm asking that it remain at $2,500.
All right. Then I'm going to leave the bond as it was set at the $2,500, so it will remain. Mr. Freeman, your bond will remain the same, though this was a technical change. Do you understand?
Yes, ma'am.
All right, good luck to you, sir. Soveni Belias.
So at Conti?
Good morning, Mr. Belias.
How you doing?
I'm well. All right, Mr.
morning,
Belias,
Judge.
you're here this morning on a change of charge. The charge was initially set at second-degree arson. It is being changed to first-degree arson of a dwelling or building where people are present. Mr. Linder, is that correct?
Yeah, it was upfiled from a second degree to first degree, Your Honor.
All right.
That being said, I reviewed the allegations. It would appear that the victims were present in the home when this occurred.
Yeah.
So Judge Barner would have been aware of that when she set the bond. She set it at $3,000. So at this time, I believe the court should keep it at the bond of $3,000.
Without objection.
All right, then I'm going to reset the bond at $3,000. And it will remain as it was set initially. All right, good luck, Mr. Belias.
Thank you, Judge.
You're welcome. Cody Harris.
Is it Maine?
Thank you. Good morning, Mr. Harris. Mr. Harris, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied dwelling unarmed. Count 2, first-degree petty theft. I find probable cause. I'll hear from the parties.
Your Honor, I'm going to ask that you set the same bond that you set for his co-arrest fee. I believe that was $7,500.
That's correct.
No contact, no return. His booking sheet shows an at-large address. At least his co-arrestee had a Jacksonville address on his booking sheet. Mr. Harris has no address listed anywhere on his booking sheet. I have concerns about his future appearance in court and ties to the community.
All right, Mr. Romero.
I was just looking at that. Judge, and speaking of Mr. Harris, I believe he's in a different situation than his co-defendant. He advised me that he's been residing here his whole life. He's 23 years old. He was previously working at Publix. Now he's not. He's looking for work. Unfortunately, he is homeless. But more importantly, and the state can certainly confirm, he has no prior contact with the criminal justice system. So, Judge, from what he advised me, he can't afford anything. He's asking to be released under pretrial, but if the court's not inclined, he's asking for a minimum bond of $3,000 on his behalf.
Not showing anything as an adult, Your Honor.
All right, since he has no prior history, I'm not going to set a $7,500 bond as I did in his co-defendant's case. However, because of the nature of the allegations in this case, the fact that it involves a residence, I am going to set the bond at $5,000. There will be an order of no return, as well as an order of no victim contact. Mr. Harris, so that you understand those orders, the no return order means that you are not to return to the location this allegedly occurred at. The no victim contact order means whether you know the alleged victim or not, you're not to be in the same place at the same time as this person. That also includes no phone calls or text messages to that person, and no third-party contact or social media contact with that person. Do you understand that, sir?
Yes, ma'am.
Thank you. Cedric Sconiers.
He's approaching Judge Maine.
Thank you. Good morning, Mr. Sconiers.
Good morning, Your Honor.
You are before the court this morning on 4 charges. Count 1, battery on an officer, firefighter, or EMT. Count 2, resisting an officer, obstructing with violence. Counts 4 and 5 are felony probation violations with no bond holds. I find probable cause. Mr. Sconiers, I do see that you have a hearing with your division judge tomorrow morning to address the VOP issue. And in light of that, I'll hear from the parties on counts 1 and 2.
Judge, we're going to be requesting a $1,000 bond each on counts 1 and 2, which are third-degree felonies, and also a photo order as well.
All right.
Your Honor, I'm seeking a $5,000 bond on count one, a $1,000 bond on count two. The court should be aware of the case he's on probation for. First, he's on 15 years probation. The reason he is on such lengthy probation is because he was originally charged in that case with 2 counts of sexual battery. He pled down to an aggravated battery on each count.
Bond on count one will be set at $3,000. The bond on count two will be set at $1,000. I will sign the foot order that was requested as well. All right, and Mr. Sconyers, you'll see your division judge tomorrow morning. Okay, that brings us to the end of our morning session. I will see everyone back here at 1 o'clock. Thank you.